Hi, you're listening to the Lawyer Society legal podcast for lawyers, practicing advocates, law students, and judicial exam aspirants.
In this episode, we'll be trying to answer a question asked in the judicial exams in Uttar Pradesh from the year 2018. The question has been quoted in the description box below. You can go and refer to it if you need. Basically, the question is regarding an accused who has been arrested in a bailable offence and has been released on bail. During the trial, the person has absconded and NBW, which is non-bailable warrants, have been issued against him. Subsequently, the police has secured his presence and the counsel for the accused has prayed that he must be let out on bail because it is a bailable offence. The question is that can the court refuse to release him on bail because he was arrested in consequence of a non-bailable warrant being issued against him? To answer this question, first we need to address the fact that when a person has committed a bailable offence, bail under section 436 of the Cr.P.C is mandatory. It is not up to the discretion of the court to decide whether the person can be let out on bail or not. It is a matter of right of such accused to be let out on bail. This has been confirmed and followed by the courts. Just for reference, if you need, you can refer to the cases Rasiklal versus Krishna, criminal appeal number 343 of 2009. Reported in 2009 4 SEC 446. The next Supreme Court judgment you can refer to is Vaman, Narain, Ghiya versus State of Rajasthan, which is criminal appeal number 406 of 2008. In both these cases, the Supreme Court confirmed the fact that there is no discretion in the hands of the court in case of bail and bailable offences. Now answering the question whether a bailable offence will be having the colour of a non-bailable offence merely because a non-bailable warrant was issued against the accused, let us look at two more cases which can be used as an example or as a reference in answering the question in hand here. One is Venkatesh Babu versus the state, which is from the Madras High Court, reported in CDJ 2009 MHC 297. The other is also from the Madras High Court, JKS Manikam versus Inspector of Police. This is from the year 1994, reported in 1994 to Law Weekly Criminal 764. In both these cases, it was said that merely because a non-bailable warrant is issued against an accused and he is apprehending arrest in execution of the same, he cannot be granted anticipatory bail under section 438 of the Cr.P.C, which provides that anticipatory bail can be availed by accused persons who are accused of a non-bailable offence. So it was particularly said that merely because a NBW has been issued against an accused, a bailable offence cannot become a non-bailable offence. So AB cannot be granted to those people. It is very evident that NBW does not change the nature of offence as such. So if you apply that logic to this particular question asked in the UP exam, it is evident that merely because an NBW has been issued against an accused, a bailable offence will not take the colour of a non-bailable offence. So 436 Cr.P.C will be applicable here also, and the accused must be let out on bail because it is a matter of right and there is no discretion in the hands of the court. If you like this episode, please do follow us on Spotify, and if you're listening to this on YouTube, please do follow us on YouTube. Do consider subscribing to our digital law magazine, the details of which have been left below in the description box. Click on the bell icon for more. Do share it with your law colleagues, your friends, those preparing for judicial exams. Thank you for listening.